Good morning, good morning, good morning. It's Wednesday. It's November 6th. We are going early to the Supreme Judicial Court in Massachusetts. I am in my comfy cozy robe. I said we were doing this in pajamas because it's early and I am not a morning person. However, I am very interested to see what the Supreme Judicial Court will decide to do, and if we will get any indication how the judges are thinking about this case from the questions they ask. This is very different than when we are at the trial court level. We are at the appellate court level. Karen Read's defense attorneys are appealing Judge Cannoni's decision to deny their motion to dismiss counts 1 and 3 of the indictment on the basis that numerous jurors came forward and said that they had unanimous verdicts. So this is on the argument that the jurors reached a verdict and therefore this violates her right against double jeopardy. So when we go into court, that is the argument. What they can decide to do, they can decide to overturn that decision. They can decide to uphold that decision. They can decide to ask that the jurors be polled and remand the decision back for Judge Cannoni to do a thing. Will they do any of that from the bench today? I think that is incredibly unlikely. The expectation for me today is we'll hear both sides make arguments for about 15 minutes, and then we should get some judicial questioning, and then we should get a written ruling down the road. That is my expectation today. If they said a ruling from the bench, I will be very surprised. But who knows? Maybe we can be pleasantly surprised. Why not? So we're going to roll the intro. We're going to go to court. If you've never watched appellate arguments before, they are much more formal than what we've watched at the trial court level. And we are going directly to the court's website for that. So, and then later today, we will have a mega episode of the podcast talking about YSL. Thank you to everyone on Team Baker who was like, girl, we were supposed to do a shorter podcast so everything could get edited. And then we podcasted for like 5 hours and now we're here. So a huge thank you to everyone at Team Baker. We're going to roll the intro. We're going to go to court. We'll talk about this more as we're waiting for everyone to come in, but I don't want to miss a minute. And because they're only talking for 15 minutes, I probably won't pause and explain very much. I will be in the chat as well, because we've heard these arguments like 4 times now. It's going to be a shorter version of what we heard the arguments before Judge Cannoni, when the arguments were, look, this violates double jeopardy. The jury came to an agreement. I, again, think that the hope here, the reasonable hope, is not that they are going to dismiss these counts. I think the most reasonable hope is that the jury gets polled and we hear from all 12 of them. I don't think any judge is dismissing a case after a mistrial is declared without hearing from all 12 jurors. And I think that has to happen if there is a path forward for that. They are getting ready to come out. So let's roll the intro and go to court, shall we? Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it. All right, let's go right to court. You guys let me know if you can hear, and hopefully the sound is good. Hold on, I need to see if they say hear ye, hear ye.
Court, now sitting in Boston with them before the Commonwealth. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now in session. Please be seated.
I did not hear ye, hear ye's.
Okay, good morning.
I'm going to try to game this up a little bit.
SJC 13.
All right, Karen Read's case is the first case up this morning. I'm going to try to gain this up. This is coming directly from the court's website.
663.
I don't know if that will help. Nope, it sure didn't. It did absolutely nothing.
Attorney Weinberg.
Good morning, Chief Justice.
There we go.
Associate Justices Martin Weinberg on behalf of the appellant Karen Read. Today's appeal goes to the core issues regarding double jeopardy protections that safeguard defendants, in this case Ms. Read, from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest necessity, without her consent, and we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a
That's true.
trustworthy, corroborated, and we contest uncontradicted showing
I see
that
Alan
the prior
Jackson in
jury
court.
reached a unanimous decision
Yannetti?
to acquit Ms. Reed of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to
What
first,
is the factual basis for your assertion that the jurors who contacted the DA's office
Already
are
questions
different
from the
people
judges.
from the ones who contacted yours?
I don't have a basis to.
Okay, so when you say 7 or 8, that's speculative?
No, those are the
What
ones
I-
that didn't contact him.
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof.
Sure.
That a 5th juror contacted the defense. A juror who could have been one of the 5 or could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I
Okay.
am contesting is that there was no manifest necessity for the mistrial, which is issue 1. There was no consent, issue 2, and that this court's jurisprudence
Okay.
strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that that voir dire would result in proof.
That's what they
that
really
there was
want.
a final and binding.
Mr.
and never-
Weinberg, you jump all the way to acquittal, correct?
Yes,
Under Rule
judges are just getting
27,
in.
the verdict has to be unanimous.
yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict.
Right.
Here, none of those elements were met.
Correct.
Oh, boy.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
Oh, boy.
It's less a matter of labels. I could call it, Judge, a unanimous
Well,
decision.
you cite Taylor, which is the case in Quincy where the judge, basically, there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error.
Yes.
That case is an opposite to what this situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declarations.
Well, that's a double jeopardy claim, right?
Yes, it's at the core of double
Oh,
jeopardy
boy.
that if we can prove, and I suggest we've more than met the burden of production of proof, more than in many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of
very
prior
unusual
precedents.
situation.
Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was,
Doesn't Fiddler caution to not inquire into to intrude into the sanctity of the deliberative process as well?
I don't think this does,
it
though.
does.
Absent this extraneous
But I don't think this does,
influence.
though.
But the influence in this case is not extraneous. It has to do with the very deliberations that occurred, correct?
I would
has to do
argue
with the
that it has
decision.
to do with the results of those deliberations.
I agree
and
with
that a
that.
carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count 1? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry,
You
Judge.
seek to,
Right, 'cause it's
impeach the written
silent.
communication of the foreperson, correct?
Right, 'cause
I
it's silent.
wouldn't, I would say that the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges, but count 2 by itself, read vertically, had multiple
tough argument
charges.
for courts of appeal.
Horizontally, there were 3 separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration of mistrial, and I contest that there were at least 3 viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered. Must be carefully
You've
considered.
got an exhausted jury writing this very eloquent message saying,
Boy, this is not a friendly bench.
we haven't been, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges or that this only relates to the second charge, right?
Facially, there was the words charges and the words.
But again, there's no inkling of what's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best, it's exhausted, it's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is there an error to declare a mistrial?
I would respectfully disagree that everybody concurred.
His point is
that there
different
was only
than the
one
previous
reading of
justice.
this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Didn't the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
Once the judge discharged the jury, once the judge thanked them and said that the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Commonwealth versus Enid Brown, where the jury goofed, essentially? There was a miscommunication between the clerk and, you know the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And had the jurors that assigned or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge.
I guess the point I'm asking, Mr. Weinberg, is there was a time period.
Right, why didn't they
and
say
I get
anything
your
afterwards?
point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may.
I see lots of questions about, is this normal? Yes, this is exactly what happens. This is what law school is more like. This is exactly what happens when you are at the appellate level. The courts don't just need you to make your time. Some courts do questions after, some courts do questions during your time. They've read all the briefing. They don't need you to restate the briefing. They need you to answer their questions, and they need you to answer their questions on point. So if they feel like you are not answering, they are going to interrupt and they are going to ask again. They have certain things that they want to know the answer to, and they are going to pepper the attorney with questions. So this is how that process works. And you can see why trial attorneys bring in appellate attorneys, where this is more standard than trial court. It is a very different practice than the way trial court is. Some trial court judges interrupt more, some don't, but this is exactly what happens on the appellate level. So we are going to keep going because I don't want this to time out as we get to the end of the arguments. It shouldn't. It should just roll into next trials. But if we want to go back and watch the hearing again, because it's going to be brief, we can go back and break it down question by question if we need to. But this is very, very common.
Decision of the first jury to recommend alternatives to the judge. And, the trial judge found consent, in part based on the failure to make an objection.
And I
Yannetti
think
asked.
we cut you off
Yes.
You said there were three things that could have happened. Could you please tell us what those are?
Yeah, one is the
Yes, you did.
trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said, bring the jury in. The jury comes in seconds later, 30 seconds, if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question. It has no capacity to coerce, the jury into redeliberating. It would illuminate
The attorney's asked is going
the
to be the problem.
implied ambiguity, which is illuminated by the jury declarations, that there were two ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes two previous notes reporting impasse? You argued very forcefully below
You're not
that
wrong,
the
Your
jury
Honor.
had reached an impasse and for the Tui Rodriguez charge to be given.
Yes.
I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that
Right.
argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer
I'm
asks,
not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note, and the third note
yes,
that would indicate any less of an impasse between the first, second, and third notes.
yes, what happened is that
I'm just looking for a record site.
the record is the jury went out and deliberated for several hours, subject to a TUI instruction, which is designed to encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all
She's
three
like, nope,
notes
thanks.
are ambiguous. The defense,
That was not the argument you made below.
the argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there was no argument that these
she's
notes were
asking.
ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was
No,
that there
at the
was
time,
ambiguity.
not at the motion to dismiss,
At the time. No, there
There
wasn't.
they had no opportunity at the time
First
to,
note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
no, there was a request
Was there
for
any
TUI.
ambiguity argument made in response to the second note?
There was a request for TUI. But the
Right.
only time that I suggest matters is the third note where they had no
boy.
opportunity to make that
Why,
argument.
why would that be? Why would we just focus not on the totality of the three notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on one count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the three alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The reporter's notes.
At the moment of the declaration of the mistrial, what suggested in the notes, the three notes, that there was any agreement as to any of the three charges?
Facially, they said
Nothing.
they were at an impasse, and
Oh,
the
boy.
court has an obligation to carefully consider all alternatives under Taylor and Stewart.
He's been steadfast,
There's no
but the
evidence on this
Court of
record
Appeals is like,
that the trial
no.
court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the two Rodriguez, and the prosecutor said, not yet. And she said, yes, no, not yet. And then there was the second note, where again, they report that they're in an impasse, quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez, and the defense counsel says, yes, go ahead and give Tui Rodriguez.
Yeah, that's true.
And she considers that alternative and gives the Tui Rodriguez instruction.
Yes.
Yes, Your
Now
Honor,
we
you're
have
not
the third
wrong.
note. We've really tried on all the charges. Some of us agree that beyond a reasonable doubt, that the elements of each of the charges have been established. Some of us do not.
And
And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required.
And the
Because we
time is
don't know
almost
that the
up.
jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. If you want a mistrial, you ask for
So
one.
your rule would be
Yeah.
that anytime there's more than one
That's not going to
charge,
go well.
the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you at an impasse as to count 1? Are you at an impasse as to count 2? As to count 3? That's the rule?
When there's a multiple count indictment, that's the rule as described by the reporter to 27B, which is a trial court must make that inquiry
I thought-
before ordering a mistrial.
I thought that it was a may, Mr. Weinberg.
The may was in the rule, the reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation of the
argument.
judge at any particular
They're not having it
time
'cause it
to
says
ask
may.
the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in.
Counsel, you know
In
they
the
fight on
ordinary
commas.
Case, the 4-person, a verdict on counts 1 and 7.
Literally their
and
job.
We seal them and
why
then
they
we
have the big
continue on
chairs.
and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples. But 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Wendlandt, and I
The
guess
timer's
to
now
me
counting up for
as
the
well,
overtime.
Court, is that that is not discretionary.
My argument is that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor, and here they complied with neither one of them.
And that's absent any other evidence as far as the deliberations go and the notes that there's an agreement, or at least partial agreement on a particular verdict, correct?
Yes, those notes were subject to one of 2 interpretations, and given the obligation of a trial court to consider all alternatives, including the alternative post-TUI of seeing whether the jury wanted to deliberate on any one of the 3 counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here, the problem is the record doesn't reflect the trial judge's consideration
As a matter of
of these
fact, were there
alternatives.
3 separate verdict forms?
There was actually more than 3 verdict
Yes.
forms because the
There was
verdicts
the
on count
objection.
2 had multiple, they had 3
So
different options.
count 1 and 3, were there separate verdict forms for those?
I believe there was separate
Yes.
forms, but there was, guilty, not guilty, count 1, count 3, and count
the
2.
papers.
There was supplemental
3 separate
instructions.
pieces
and
of
amended
paper, 3
verdict
different
form
charges.
To make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, are you done? So I'd like to ask, how are you, the judge says she can't ask the questions that you're saying she could without interjecting herself in deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instruction given to the jury by the court were confusing, determining whether this
He's reading the judge's ruling because what they are appealing is the judge's ruling. He is going back to the judge's ruling to ask questions about the judge's ruling directly on point.
doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were. Just tell me what your thought process is on
Well,
that.
my thought process, one is that this court has the option of essentially informing the court what questions can be asked. And two,
But
if we're
again,
going to
they're
delegate.
going to require follow-up questions. And unlike extraneous influences, where you can say, okay, we only want to
The Murdaugh
inquire about
situation.
whether there was a racist statement made or something to that effect. This is different. We're going to have to require what their votes were and how solid they were. Isn't that going to get into deliberations inevitably?
I think you can ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation. But I want to ask you the following questions. One, did you take a vote on count one? What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That question, was it final? Isn't that going to, the jury can change its mind, right?
Could, but there's no.
But
There's no
isn't
indication of
gonna
that.
result in asking that type of question? When you say final, you
Don't you have to ask again,
don't get
right?
your way on two, is it final?
Was it ever reconsidered? You know, my contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror who they served for months says to anybody, to the court, to the clerk, to the court officers, to the prosecutor,
Well, they
wait,
also,
I
they
didn't
also
agree.
don't, they also don't write in saying we agree with the other five or anything to that effect. They're silent as their deliberations are supposed to. See.
But it's an almost unprecedented meeting of a burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what juror D says. We went to the bus and says no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep
It is
saying
kind of
that
part of the problem.
whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity
think
for
they were
folks to
done.
change their positions in the context of the continuing deliberations
They
on
weren't gonna-
count 2 and
But
its
they
lesser
weren't going to
included.
go back and continue to
So
deliberate.
what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we
Can't
don't
know
know
that 'cause he can't ask.
that no
That's the
one, to
problem.
Justice Kafker's point, has called and said, "Hey, me too. We believe the same thing." For the court to say that
Right, but they
this
can't
is what
ask.
it meant for all time.
That's the catch-22.
The answer to the question, and I understand the question, in the Bluford case, you know, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point. If you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's
they were gonna
change of
declare the
position
hang
on
there.
count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the McCallop case, you know, we allow a court to ask about mental processes. Was there this communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper
He knows his
function
case law
of the
incredibly well.
trial court. This is important. Ms. Reed was acquitted by those jurors, and we should have the opportunity, or if not acquitted, we contend a unanimous vote. We should have the opportunity to have Judge Cannone conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with
Right,
an
but when
external
it's an
source.
extraneous
The law allows it.
source, then you need not get into deliberations.
Right.
But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And I would contend they go to the results of the deliberations. They do not require a judge to ask, why did you vote not guilty? What led you to vote not
So
guilty?
the question
Did you
asked
vote
to
not
juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended
And then
on
there's no further
how
question.
I would have voted on count 2. We were not yet done.
And that would reflect two
The
things.
jury deliberations, right?
And
That
that's
would
the problem they're going to
reflect
have.
that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are
They've given him
going
a
to
ton of
say to
time.
Judge Cannone, if conducted, that was my vote. It was not guilty. We never reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury
instructions
were
suck.
instructed to return a verdict after the final vote, and I'm using that as a direct quote
That's
of the
what the
jury.
instructions say.
So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? And we have a long line of jurisprudence that says we presume that the jury follows the
The
instructions.
video feed froze. It's not you.
And there is cases where, when mistakes are made by jurors, where they don't,
That's the feed from the court that froze, not you.
case I think
There we go.
is a stronger case for a voir dire because
The fine-tooth comb is the entire jam of the appellate court. So when they are fine-tooth combing the jury instructions, that is exactly what they do.
to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity.
Okay,
and the
before you shift back to that, what's the best case?
Nope.
Best federal case, because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing?
That's the big
after-
issue.
What's, if we want to go back and read one case that's
It's
going
a-
to do what you want us to do, what's the closest?
That's a friendly
It's actually a
question.
Mississippi case. I think it's named Martin versus
That's a-
State, that the amici
That's a
brief
state court
brought
case,
us
right?
to, where they read the
It's a state
newspaper.
court case, right?
It is.
Any federal cases, because again, this is a federal constitutional issue.
You know, there are cases where jurors correct verdicts.
No federal case
This is,
that has the, you're asking us to direct Judge Cannone to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
well, this court has a long history of
Yeah,
applying
but we don't
federal
have any
constitution.
cases except extraneous influence cases. I'm just looking, again, your chance.
You do
Best
have-
case that we should look at for you.
You
He's
do
trying to
have
help you,
one
man.
example, which is the McCallum case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial bias.
Again, that's extraneous influence.
extraneous influence.
It's different.
It's internal, I think it's closer to the core of 606B.
No federal case we can turn to, for example.
Nor has the prosecutor come up with any case
There aren't
to the
any.
contrary. This showing by this jury, it's not going to open the floodgates for post-voir dire.
Well,
This is-
actually, that was my question. What's the limiting principle here?
He's like, of course it
It
is.
sounds like if
This is the
ever
Chief Justice,
a juror
Chief
comes
Justice
back to the
Budd.
defendant and says, hey, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think she was, he or she was listened to in the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty, and I
So the
urge
jurors submitted affidavits?
The jurors would submit affidavits if, we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted
we were doing it
the
right.
truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has
That's what he
the
wants.
power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning, did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules. It's Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know
knows
whether
this case law
counsel
so well.
would have advised the judge about 27B, or would have asked the judge to ask the jury whether to.
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think potentially a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that
Everybody knows
wouldn't
what's coming
think
next.
they might get a mistrial on this. So you know where the puck may be going when it comes to giving to Tui Rodriguez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table, is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
So let me address that.
It's a good question.
Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If your honors would accept the audio video that, again, the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity. They hear a door open. The jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections.
Wait,
So
the judge said they're at an impasse, bring in the jury?
Bring in the jury,
Yes,
and you can actually hear
immediately.
a door open.
Okay,
So
and you have
when-
30 seconds to object?
But you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the
You
jury
can't say,
can't
Your
hear.
Honor, may I see you at sidebar?
Oh, God, not in this
In this
trial. They
case,
couldn't.
That's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was in
But
the
they did
note.
know that the jury had reported to her that
they
they
were
were
at
at
an
an
impasse.
impasse.
They were in an impasse, bring the jury in. Yes, that was possible, but to
What was possible?
to ask to go to the bench, but
Yes.
this
And
court
did that
has-
happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign, they want to re-prosecute somebody after a mistrial, to subject them to the perils of a
this
second
one's on you, though.
prosecution. The trial court did not impose a burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial,
After
correct?
careful
Accurate.
consideration of all alternatives and after giving
So
the
that may
defense.
explain why perhaps the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted a verdict.
Mr. Weinberg, are you aware of any cases, or can you let me know if
defense
there are any cases
Asked for
where
two Rodriguez
the
earlier.
judge gives TUI,
Yep.
and then the jury comes back and says, we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than just declare
Right.
mistrial?
Well, the statute itself says the judge has no right to obligate the jury to
21 minutes
redeliberate,
overtime.
but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Yes.
Right, and in the face of that,
the
you
f-
think
strong
give it the old
note.
college try is okay?
I think that the judge had alternatives, that the record does not reflect were carefully considered, including, is your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination.
She could have told the jury,
post-
is what he's saying.
Post-July 1, and I'm not arguing that that provides proof as to what the process was.
Again,
on
And
July 1.
in the statutes, again, is a may, correct?
The statute says, 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, a number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence.
That goes
of
back
this
to what he
court,
just said, though,
and I
counsel.
contend it contradicts the
After
court
Tui Rodriguez, that's
protections
exactly what happens
that double
next.
jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, Secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it a life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you.
They let him go 24 minutes, almost 25 minutes over time. It is now the state's time to make their arguments. I'm interested to see what questions they will ask of the
Good morning,
state
Your Honors.
here.
May it please the court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
The judge did inform counsel that the jury was at an impasse, and I would argue at this point, it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given to E. Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the victim did cause, or excuse me, the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more.
Well, rather than speculate what the defense wanted, let me ask you about what happened. Did the judge have either the discretion or the obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. Perhaps as a matter of...
Did the judge have the discretion to do so?
Rule 27B
Yes.
is discretionary.
Yes.
The language of the rule itself
The answer is
consistently
yes.
refers to what a judge or a jury may do. I know the
So
defendant
it's,
argues...
so it's not inherently coercive?
No,
If the judge has the discretion, it can't be coercive, correct?
Well,
Correct.
no, it's a matter of discretion, and then consider the factors that inform the exercise of that discretion.
Those are-
And that's what
those
the
are
judge
tough
did
questions.
consider here. On the one hand, the judge had no doubt, based on the jury's notes, that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It'd be the product of compromising their deeply held beliefs and moral convictions.
Which they said
You have
in the
that
note.
on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits. Now 4 or 5 days of deliberations, they've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why, when we talk about what potentially we could do short of saying, mistrial, let's start again?
Yeah, certainly, Your Honor, and I think, in hindsight, seeing, the quote-unquote remarkable turnaround of the defendant's position, would it have been better, would it have been preferable for the judge to take that extra step, perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those two prior notes, I think the judge could reasonably conclude the jury is at an impasse. There is a manifest necessity for a mistrial. There is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
But you can't find consent, right? If you don't ask, the consent is out the window, isn't it?
I don't agree, Your Honor. You can find consent through the lack of an objection here.
The judge is like, really?
The burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get you may have manifest necessity, but I don't see how you can get consent when they haven't been consulted in any way.
They were consulted in response to the first two notes. And what was the
That's not
defendant's
what he's
response to
saying.
those notes? It was to argue in favor of due and thorough deliberation and accelerate the process at every step toward a mistrial.
But
They asked for the
pushing
two-way
towards a
Rodriguez.
verdict is different.
That's what you should have argued.
That's different. I mean,
Right.
they want a verdict. Because they want
They wanted a verdict.
Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunities to object. They could have objected while waiting for the jury to enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's at an impasse. They could have brought the issue up again during the scheduling conference after.
Again, it does strike me that the defense argued fulsomely that in 22 seconds in that the butt dial phone call that there was an entire conversation coordinating a cover-up. So to then argue that 30 seconds wasn't enough time for them to point anything out, I'm waiting to see if the prosecutor gets to that. Probably not, but it's funny because the defense is like 30 seconds was not enough time to do anything, but at trial they're like 22 seconds the entire world. So it's interesting. So let's continue on. They are talking about whether or not there had to be a mistrial declared and really hammering the prosecutor on that point. And again, this is the appellate attorney for the Commonwealth.
So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Oregon is an example of that. Judge comes in, abruptly announces, trial judge is unable to preside, I'm declaring a mistrial. There was no indication there that, the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared to not.
How do you know the defendant is advocating for a mistrial as opposed to pushing?
It's a good question.
Because, Your Honor, not just what they argue, but what they argue.
Because Tui, there's two results of Tui. It's either a verdict or it's a mistrial.
And they argued they were
pushes
pushing
the
for a
jury
verdict.
to its extreme. So when you say that they're advocating for a mistrial, they could have been just as well advocating the jury for that final push. As the Tui Rodriguez instruction says, you need to check yourself. One side has the burden of proof. It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Perhaps as to just Tui Rodriguez, although as a practical matter, as Justice George has pointed out,
you're not
experienced defense
answering that
counsel
yet.
understand that there's not going to be a mistrial before that instruction has been given, or very likely. But set that aside, Your Honor.
Well, I think experienced counsel know that you're most likely not going to get further deliberations. But
How can you stand up here and say
counsel
that is a
also know that
pointed
it could very
question?
well, it's a flip of the
Pointed.
coin. It could be a verdict or it could be a mistrial.
Right. On top of that, Your
unfriendly.
Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time, let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, we believe there's been sufficient time. Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing that they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered. and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a 2E instruction, correct?
Yes, they asked for that as well in response
Right.
to both notes, Your Honor.
Do you need consent in order to win?
No, Your Honor, there was manifest necessity for the declaration of a mistrial here.
And so absent the consent, we can just, you think the manifest necessity existed?
Yes, I don't think
She's
that
like,
the judge
really?
abused her discretion in declaring a mistrial for manifest necessity based on the jury deadlock in this case for the reasons that we have discussed and were discussed with my brother.
But counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues, where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in the record here, where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of declaring a mistrial. Is there no calculus here that says that perhaps there could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively think about this, and perhaps we can all come to some other vertical other than declaring mistrial.
Yeah, and I think it's clear from the judge's order that she was cognizant at the time of these countervailing considerations, looking to the jury's notes, the lack of any indication of agreement on the charges, balanced against the risk of coercion, the defendant's trial strategy, and the fact that the defendant had not been advocating for the judge to do something more. I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps. But the judge's determination here, which is
That's a
owed some deference,
concession.
if not an abuse of discretion, was not outside the range of reasonable outcomes, given the jury's notes and these other considerations, Your Honor.
You don't think it would have been coercive to say, come on, jury, I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs, but did you reach a verdict on count one?
I do think that would be extremely coercive, Your Honor.
But that's
yes.
not what they're asking.
And I would point the court to footnote 5 in Ray versus Commonwealth, where this court said or noted there may be a prevailing practice among federal courts about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry, but that is not the prevailing practice here in Massachusetts and is not an encouraged practice, particularly because of the risk of coercion.
I take it Rule 27 doesn't, there's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind, right?
Correct.
But, so I see your point on the note is so compelling that
Pointed.
they've worked this to the end. But then the problem comes when we get this new information that's somewhat inconsistent with
That
that
note.
they've, I mean, the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely,
Charges.
others find the evidence fails to meet. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
And I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already...
I get that, but I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have some follow-up obligation here. Is there no obligation whatsoever, I guess, is what?
No, and we argued below, actually, Your Honor, that it's not reliable or competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
Accepts, the judge makes a finding that she finds them credible for the purposes of this motion, right? So
Right.
she doesn't say they're unreliable, but rather accepts their reliability and then concludes that nonetheless that she can't inquire here without invading deliberations. It's different from reliability. She's given up the reliability point, right?
Yes, she conceded it.
She's made a finding that I accept for
Yes.
these purposes that those 4 jurors or 5 jurors
Accurate.
Correct.
are credible, right? So it's not a reliability issue that you can rely on, right?
Correct, but the
You're
judge
not
also
trying that, right?
correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged, they've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
They can be pulled,
The-
can't they?
The request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
But not to get into their
But
deliberations.
that's a separate matter. You said that, you can't bring this jury back. You can bring them back for
He's like, yeah, you
post-verdict
can.
inquiry.
Well,
You actually
it's
can.
one-
Under the guidance of Fiddler, et cetera, right?
It's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury back to essentially construct a
And
verdict
that
that
what
was never
Mr. Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike
Why not?
Oh,
Why is the Fifth Amendment any lesser of a right than the Sixth?
it's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of 2 competing public policy
He is now
considerations.
over
It's
time.
not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations, and I think my brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject
wasn't
to
persuasive the
extraneous
last time.
influences, potentially including harassment.
We've
or
sent
threats.
back jurors
Yeah.
on race, I can't remember how many years, it was like a decade later or something. We've,
he's like, yeah, that's no big deal.
timing's not going to be. a
NBD.
winner, is it? It has to be.
No, that by itself, Your Honor, is not a reason not to do it. I'm raising it as an additional consideration or concern.
Court etiquette in this court, my brother or my sister is the etiquette for my colleague. So my learned brother-in-law, my learned sister-in-law, that is etiquette for my colleague. There are different etiquettes to different courts. This is a entirely different etiquette than the trial level court. So it is a court etiquette thing. Their website actually breaks down the etiquette of what to expect in this court for people that don't practice. But that is why he keeps saying my brother. He's not saying Weinberg is literally his brother. It's, my brother at the bar here. And the bar meaning what they're standing at to argue, not where you go drink. But they might be doing that later too.
Brief is,
It's
did you reach
etiquette.
a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
I don't know that that was the specific question they proposed, but I understand.
Whatever.
I take Your Honor's point.
I mean, however
Yeah.
they phrase it, it's a limited yes/no question.
Yes, and my point is that's an artificial inquiry. Or take, for example,
But we asked,
Did
have you reached a verdict? That in and of itself is a standard question, right? That can't be crossing the
Coercive.
line, right? Or is it?
no, but again,
not coercive.
I want to reemphasize the point that was raised earlier, which is imagine a juror had tentatively agreed to find not guilty on a particular charge. But that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges.
That's not
You now bring the jurors back and you simply ask them, I don't want to hear anything else. I just want a yes or no. It doesn't give that juror any opportunity to explain that their agreement was tentative at that point. And so it's an artificial exercise to say,
Is that what Bluford, is that, Justice George asked your brother counsel about Bluford? Is Bluford the answer for you, that that's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it's only in lesser includeds that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
would argue that it is, and I'd actually take it one step farther, which is not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been the product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty.
And if they're
So
polled,
even if,
then we know.
like counsel wants to argue, this was a final vote, this was a final decision, you still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bluford, or is the different?
To characterize counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form, although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form.
And that's
or
the
I guess more
difficulty
to
here.
the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement where it said, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bluford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Bluford limited to lesser included, or is Bluford?
That's a
is
very
Bluford
good
broader
question.
than a lesser included opinion?
I don't read it that way,
No,
Your Honor.
it's
No, I
not.
read it as the general proposition that there are multiple
broader
charges,
than
whether
that.
they're lesser includeds or not. Jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless, the jury remained free to go back and revisit a prior vote because that's what jurors do. And it wasn't inconsistent with the instructions. I want to emphasize one other point, which is at most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants too. You could imagine a different scenario where a juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration.
Well,
Unless the.
we're dealing with
Your
Sixth
Honor, if any
Amendment
other
rights here,
questions
not
come up,
convictions.
The defendant's petition be denied.
Okay, thank you very much.
And they have no further questions. The
Court,
state only
all
went.
rise, please.
The state went 8 minutes over, and they are done with the Karen Reed oral arguments. Justices out. Yes, they are very big chairs. Look, it's an appellate court. The big chairs.
Court stands in recess. Please exit the courtroom.
So court will be in recess, everybody out, and then they will bring in the next case. They're going to have numerous cases today. And at some point in the future, they will render a written response. So for all of you that have never watched an appellate argument before, if this was your first time, it's different, isn't it? You can see the library of law books behind the curtain where they go back to their chambers. A different type of argument for sure. And this will also be up on the Supreme Judicial Court's YouTube channel later. So if you want to go back and rewatch arguments, you can. And I'm going to go through some of your questions, but it is very much a different procedure than at the trial court. You see Weinberg and the appellate team for the defense going over and thanking the appellate team for the state. No, we do not see Adam Lally in court, though we saw his co-counsel in court. A different appellate lawyer for the state, which we expected because that's who signed the pleadings. But they go in, they answer all the questions, and then they're out, and then they wait for a written ruling. But the appellate court definitely asks pointed questions. You need to go in knowing your case law that you cited inside and out, and then ancillary case law inside and out. So we are going to, as they all leave the courtroom, we are going to do a summary and then I'm going to answer questions. So we had an early morning here. I'm going to wait and see what else as they exit the courtroom, if anything else happens in the courtroom before I do a summary. But they will, oh gosh, I don't know how long this court gives a written ruling. For appellate courts, it can be a couple of months. So I wouldn't be anticipating it anytime soon, especially now that we see that there's already been a request to continue the trial. They are not up against any time constraint. So it is not something I would expect swiftly. It's something I would expect down the road. It is not a swift process. So let's see. All right, everybody is out. Let's do a quick summary and we will go from there. I don't know how much, because Miguelina, I don't think we're going to end up clipping this down. We're just going to leave this up, but we'll do a quick summary for those of you that popped in the middle. So this morning, a very, very early morning on Wednesday, November 6th, Karen Reed's appellate counsel and appellate counsel for the Commonwealth were before the Supreme Judicial Court of Massachusetts en banc, which means the entire fleet, the full fleet of justices. Emily, are you tired after streaming for 5 hours yesterday? Huh? The full fleet of justices listening to this case. They took this case pretty swiftly, and they took it with a full panel, indicating that this court is very interested in this question. We saw the justices asking the defense, are there any federal cases on point here? And there are not, which is part of the problem here when looking at the defense's argument that this goes against double jeopardy. The difficulty is that this is an incredibly unique situation. Generally, the only time that you can inquire into a jury is when you have those outside influences, those extraneous circumstances that we've seen in other cases, whether there were limited types of impropriety within the jury room or if there was outside influence into the jury like we saw in Murdaugh. So was there impropriety or was there outside influence? But it is never the case that this comes up, or it has not yet been the case that this comes up when after the case, the jury's like, well, see, we reached a verdict and no one asked us about that and we didn't know what to do, which is why you saw the court talking a lot about whether or not they can poll the jury. Can they ask the jurors, did you reach a verdict? Or does that necessitate questions that start to invade the providence of the jury? You cannot inquire into the deliberative process. That law is incredibly well settled. So when you're looking at, are the appellate court trying to thread the needle of what's being requested here? Yes. Did they go over this entire record with a fine-tooth comb? Yes. Are they looking for the littlest of details? Yes. They are the appellate court. So if it feels like a game of tennis, this is not personal. They are peppering both sides with questions as an intellectual exploration of, well, if this is true, then what about this? And if you say this is true, then what about this? Can you stand here and tell me this or that? And the defense had multiple points that they were arguing that we have gone over in the briefing and in the more thorough oral arguments in front of Judge Cannoni. And that is one, that there was no manifest necessity of a mistrial. So Judge Cannoni, they are arguing, committed error in declaring the mistrial the way she did. There are two ways to get to a mistrial. Either the judge finds the manifest necessity or there is defense consent, which is why you saw the back and forth about, well, you're not going to say that the defense consented to a mistrial here. And the state was like, actually, or the Commonwealth was like, actually, I am. Actually, when they asked for Tui Rodriguez, they knew that the next step was a mistrial. And the court pushed back and said, actually. He did not say, well, actually, but vibe. Actually, maybe they were pushing for a verdict and not pushing for a mistrial. So you can't argue that they were pushing for a mistrial because they were really pushing for a verdict. So you can't really just argue that they were pushing for a mistrial and therefore they consented to a mistrial. And then asked more if there was manifest necessity here, which had been argued both at the level of Judge Cannoni at the trial court level, and then was briefed pretty thoroughly here because the defense had multiple points they were arguing on. The heart of the issue here is, do you get to poll the jury? Because we don't even get to dismissing the charges if a jury is not polled. An appellate court's not going to do it. I don't think they even can do it without knowing what 12 jurors said. However, polling the jury leaves us in another conundrum. If they poll the jury and the jury comes back, yes, we reached unanimous verdicts, then what? The jury's been discharged, a mistrial's been declared, it raises other questions. Angel in chat said, isn't it mandatory to poll the jury? No. In Massachusetts, it is discretionary and it is not the common practice. So when the judges were parsing, doesn't it say may? Yes, it does say may. Abby asked, Emily, are you in your PJs? Yes, yesterday I told you we were going to do a pajama party for the very early morning in the Supreme Judicial Court. We were going to go to the Court of Appeals in our comfy cozies. And so I am in my comfy cozies. I could try to argue it's a cardigan. It's totally not. It's my bathrobe. Why? Because yesterday I said we are pajama partying this morning, and we did. So yes, I am. Yes, I am. Did this morning I double think it? I did. And then I was like, no, what we're going to do is be up really early with tired under eye bags and be in my robe. I told y'all I was going to. What we're going to do is be consistent. I had a moment where I contemplated and I was like, nah, we're doing it. We're sending it. I'm also in my slippers. I have very large feet. But I am in my very fuzzy, very, very cozy Sorel slippers as well. So did I hold the bottom of that so you don't know exactly how? Yes, large feet. My brother also. It is a family trait. I have very good balance. I'm not as tall as I would like to be, but I have very good balance. But anyway, so very fluffy, very cozy. Look, we needed some vibes today. It's early and we are in front of the appellate court. For everyone that said, oh my God, this would make me actually poop. I hate this level of questioning. This is lawyer fun. Appellate lawyers who enjoy the intellectual exploration of law love this shit. This is what lawyer conversations look like. When lawyers do the arguendo, they're not necessarily arguing for a side when they're conversing with one another. It's like, yeah, but if this, but that, but if this, but that, but what about this? It's not necessarily when you're having lawyer conversations with each other that you're fighting. It is a full back and forth intellectual exploration of a thing. It doesn't mean you necessarily agree with the thing or disagree with the thing. It is a, yes, but what about this? But yes, but what about that? So that exploration is a lot of what law school is. If you've watched Legally Blonde, you see that back and forth. This is very much what law school is between not only you and your classmates, but you and your professor. Your thinking gets dialed in better under really fervent and thoughtful questioning. The thing is, in broader non-legal society, if you asked somebody this many follow-up questions, most would respond with, why are you fighting with me? The neurospicy crew, though, is very good with this, right? The neurospicy crew that maybe sometimes it's hard to read people asks a lot of follow-up questions. It's like, no, I'm not trying to fight with you. I'm just asking follow-up questions because I don't quite understand. So I just want to get to where you're at. Like I want to understand where you're at so we're at the same place. And there's a lot of that from the Court of Appeals. Well, you said this, but what about this? And then what about this? And then what about this down here? And you keep following that line of exploration. It doesn't mean that the court is leaning towards one side or the other side. It means that the court is asking questions. I would submit to you, fine law nerds, that if the Court of Appeals has very few questions for you, you should be concerned. The fewer questions that they have, the more concerned you should be. Because if they want to know nothing from you, they are not very interested in your argument. The difficulty for the defense here, and I've said this from the beginning, is that the defense is asking them to do something different, do something that has not been done in this way. And anytime you ask the court to do something weird, they are often hesitant to do it. Courts follow precedent. The person before me did this, so I am going to do this. And the law changes in slow, tiny, little increments. So this might be an incremental shift of, in this particular situation, we're going to allow inquiry into the jury. But I also worry that this Court of Appeal is going to say this pushes too close to inquiring into the deliberative process. We will see. The defense has always, in these arguments, been on the back foot. Though I agree there is room to ask the jury what they decided. And I think as one of the justices asked, doesn't the public have an interest in knowing what this jury decided? Though that is where my personal opinion is. I think there is also room to understand where the justices say, yes, but we need to understand if this is a final result. And that requires one question too far. And if it requires one question too far, then we are not going to send this back and remand it back to Judge Cannoni and ask. But the defense very much explored, or the court very much explored, what does this look like when we allow, if we do, this to go back to Judge Cannoni? And that's where we saw so many questions of the defense about what does this look like? The court's not going to ask, if we send this back and do what you ask, how does that work? If they're not curious about the defense's input on that. So the most likely outcome on this is that they do nothing. That is the most likely outcome, just so we manage expectations. The most likely outcome is that the Court of Appeal says that the court is within their discretion, that polling the jury gets too close to asking about the deliberative process. That is the most likely outcome. The second most optimistic outcome is allowing a poll of the jury. So those are kind of where we're at, but I will be surprised if they do anything other than say there was no abuse of discretion here. That is where the expectation needs to be. The attorneys argued, well, the command of the law that Weinberg has is insane. I can't put into words the way that we saw Weinberg not only weave in arguments from the case law that they cited in their briefs, but from other case law adjacent to it. It is incredibly impressive. I have never wanted to be an appellate lawyer because I do much better at the trial level. I love the stories of the trial level. There are lawyers that love the nuance of the appellate level. This court said this, and then there's a carve out, and then the dissent said this, and then the agreement said that, like on and on and on, and have every single case name in their brain ready to go. My brain is full of song lyrics, not case names. When I remember cases from from law school and what have you, it is always the fact patterns. It is never the names of the case. I was never, ever cut out to be an appellate attorney. Though sometimes I do. Don't ask my spouse. Sometimes I do love a fine point detail. But didn't you say precisely this 7 months ago? I love the story of the trial level court. I love seeing it in action because I find it to be incredibly impressive. And so I know that at the beginning of this, until we got to the end, some were sitting going, but aren't they being rude? No, they're being direct, and they are being very mindful of time, very firm boundaries with the Court of Appeals. You're not answering my question. And then they jump back in. But what I think you will see as we got to the end of their arguments is that they treated both sides the same way and had less questions for the Commonwealth. And they talked about the Commonwealth's burden. And they said, well, you can't really say that the defense consented here. And what about the judge not allowing time and breaking with the way that they had done it before? What about these different things? We saw questions for both sides. So I think when we are looking at assigning, rude is kind of a value or an emotional judgment to court proceedings. In the Court of Appeals case, this is normal. So this is what is consistent and what is expected. So it is, when it is within the norm, to me, it is not rude, but I can understand from an outside observer, if you've never seen questioning like this before, if you were questioned like this in your everyday life, that is how it would feel. That's not how it feels to these attorneys. This is them on the field playing their game at the highest level. So this is what these attorneys look forward to. It doesn't mean it's not hard, but we definitely saw Weinberg in his element. We saw the Commonwealth bring in their appellate lawyer. Most district attorneys and public defender's office have an appellate division that are the lawyers that deal with this specifically and precisely. It is a different way to law than trial level law. And we saw, I think, very good appellate work here and very pointed questions by these judges who keep an incredible amount of detail in their brain. So hopefully it was educational. I hope to set expectation accurately. Just because I might want an outcome, I very much want to hear from these jurors. That is the outcome I would like to see. It doesn't mean we will get there, and that doesn't mean that the appellate court is wrong on that. What is being asked from the defense is the difficult thing, but it doesn't mean it's done either. This is on the motion to dismiss. They don't have a ton more motions to make, but we will see if the defense makes any additional motions, because then we will get into what the fight of a retrial looks like. And we talked a lot about the fact that the prosecutor's office, a lot within the prosecutor's office, it seems, based on the article we covered more thoroughly than I had attended yesterday, but then we were in it, what the prosecutor's office thought was a case that they didn't want to retry. Are you surprised? No, I'm not. So it's going to be very interesting to see how they write their opinion, and we will go through it thoroughly when they do. I'm not going to leave you hanging. We'll talk about it together. Janine said, I really appreciate your perspective on how lawyers enjoy this aspect of appellate work. I was struggling to imagine how someone can enjoy such intense questions. Lawyers are broken. We can also be, look, I think law fits really well with people who enjoy fine point detail. It's like, engineering requires math, but I love that amount of detail and words. So law, it is something that some lawyers get into their 1L of law school and are like, I fucking hate this. I want to be in-house counsel somewhere. Never make me do this. And some people light up inside and they were like, I like the intellectual jousting. Some people love to go to the gym and lift the heaviest weights they can find because the pain is delightful. Some people are like, miss me, I'm taking a hot girl walk in a Pilates class, which can also result in pain that's delightful. So it really just depends. And I think there's a lot of room to self-select in to the kind of profession in law you like. There are some attorneys who never want to stand in court and argue and just want to write, and they get to do that. There are attorneys that just want to be in trial court in the moment, on their toes, fighting and advocating for their side, and that is what they want to do and never want to do appellate work. Some attorneys want to go through and know everything every appellate court has decided and help form new law, because you really do that at the appellate level. So it really just depends on what area of law. Law has so many areas, and areas in court, out of court, areas in traditional practice, non-traditional practice, areas in companies. Find a company you love, they're going to have a fleet of lawyers. So it really just depends, and lawyers get to self-select in. Lawyers who don't want to do this are never going to accidentally find themselves at the appellate court. This is what they like. So, yes, some people enjoy it, but here's the thing I like about arguing in court, because I am generally not a super confrontational person by nature, unless there are rules and boundaries. Again, neurospicy. Court has a lot of rules and boundaries, and you know them. They're not hidden rules and boundaries. So you know what you're getting into because it's very much contained. And so when everyone's playing by the same rules, it contains and builds a container for a safe space that to the outside world might look really weird, but contains a safe space for this is how this happens. It is predictable. You know what to expect going in. You know there's going to be hard questions. You know what they're going to be about. So you are also incredibly well prepared for what you're doing because you need it or you know it. And everyone abides by those rules because everyone is also agreeing to those rules. When the rules go off the rails is when you see lawyers getting real mad in court, right? They're not playing by the rules. At the appellate level, that doesn't happen very often. At the trial court, things are a little more fluid. Things are a little more fluid. So it is definitely a different aspect of law. I hope that you enjoyed going through it. Let's get into more questions. But I hope that you enjoyed seeing a different side of law than we normally cover, because we generally cover trial level and then we cover appellate level just by the documents. Valerie said, what's up with my brother? It is the etiquette in court. It might be the etiquette for all of Massachusetts, but it's clearly the etiquette in this court. And we saw both sides say that. KFAS said, I'm an RN and an excellent one, but I've always known I should have been a lawyer, lol. Look, there are very RN thinking on your feet, making impactful decisions with the information you have at the time you have, working on tired and knowing quite a lot of information in your brain that you need to readily pull up at the drop of a hat. It is not entirely different. CJ Drake said, why is the lighting so amazing in that court? Appellate courts are made to be grand. It is meant to feel like when you are standing there, it looks like something out of Star Wars. They are all sitting up there with their giant chairs looking down on you with the weight of the law. It is meant to feel imposing. But the lighting is great. I appreciate it. Doctor Who said, problem is lawyers just can't stab people. RNs can. Yes. Look, I worked very briefly as an EMT. Blood was not something I was always good with. I was good with the photos. I was good with crime scene evidence. I wasn't good with it in the ER. So we all find our way a little bit. So let's see. Kristen said, do you find it surprising more jurors haven't come out for or against this issue? No. I think chat, let me know how you would feel. If you were a juror who had not spoken up, would you just wait to see what happened and just keep it to yourself? I think a lot of people might just want to wait. This case is incredibly intense locally, so I can understand jurors being like, I'm just going to wait to see what happens. I'm just going to wait to see what happens. I'm just going to wait to see what happens. So I think a lot of jurors might just be like, I'm not going to say that I disagree. I'm just going to wait. So no, I'm not surprised. I'm surprised how many came forward to begin with. And I think if a juror thought that what was being represented was not true, they would probably come forward. So it's a very individual decision, but I can understand why. Did I play the Did I play the bumper for Q&A? I don't think I did. Lori said, what's your gut sense on what they will decide? I can't get a sense of what they will do with the case. Look, the easiest path for them is to do nothing. What's being asked is different. Courts don't often like to wade into doing something different. So the easiest response is to not remand it and to deny the appeal. The next option is to allow for the jury to be polled, and I don't know if they're going to get there. So we are getting to the what is the harder decision for them to make? The harder decision for them to make is to allow the polling. That is the more difficult decision for them. The easier decision is to deny it. So we will see what they do. The law is not on point with anything the defense is asking to do. It does not square with anything the defense is asking to do. That doesn't mean it is not the right thing to happen. But when we're looking at the Court of Appeals, what the law says is what controls. So we'll see what they say. But there aren't cases on point. There aren't judges that have tread this water before. It is an incredibly unique situation. We didn't get to questions, right? So that in the chat asked, but what about fairness? Unfortunately, fairness is not one of their considerations here. Their consideration is, will the going forward of a trial violate double jeopardy, and can under the law the jury be polled? And if the answer is under the law the jury cannot be polled, then that is the response, and Karen Reed gets a retrial. And I think for the appellate court, allowing a retrial is the the easiest answer. She has the opportunity for a retrial. So if they do not see this as the jury reaching a verdict because it was not on a verdict slip, then they are going to say there's no constitutional violation here. So the proper result is to allow this to go forward to a retrial. So that is how they are going to see it. But the law, the morality, legality gets parsed completely out. If any of you know lawyers that at times, and there are times I really run through my brain and I'm like, no, I can say that in a more compassionate way. I don't always do it perfectly, but there are times that lawyers, when they respond to things, are very neutral in a way that can almost seem cold or callous or crass. And it's because law is trained out of, like, this is where we might have the morality side of it, and this is how we have the legality side of it. And you go through all of the legality side of it first before you get to any of the morality side of it. The legality side of it is where you evaluate things first. So you might end up with legal results that do not feel like the just result, but they are the legally proper result. And that is where we will get into a civics lesson of multiple branches of government. And that is where it is like, okay, but then the laws need to change. If the law result does not match the morality result, that is where laws change. So that's really the answer. That becomes different branches. It's like, if this is not the result that is desired and this result keeps happening, it needs to change. In this case, I would argue that perhaps it is time to maybe take a look at the jury instructions, right? And if you take a look at the jury instructions, maybe there's room here for the Judicial Council in Massachusetts to take a look at this result and be like, this result is not the result that we are considering or that we want to have happen. And so because this is not the result that we want to have happen, maybe it is time for us to reevaluate the jury instructions. Because at the end of the day, Karen Reed will get a new trial. And so she is not sitting in custody. She has not been convicted. At the end of the day, she still gets a new trial. But with the judicial councils that look over jury instructions, there's room here, I think, to maybe have an argument or a conversation that there were some vague parts of the jury instructions, or as one of the judges pointed out, the jury instructions were working as intended. The judge cited directly to the jury instructions saying, but doesn't it say When you have reached a verdict on all counts, fill out the verdict form. And perhaps it is time to have a conversation about that. But some jury instructions are written specifically to encourage full verdicts, not split verdicts. Some jury instructions are written differently, and we've heard jury instructions in numerous different jurisdictions at this point. And so the way that the jury instructions are written is incredibly impactful, but that is not unintentional. That is awkward, double negative. That is intentional. When there are these conversations, is it better to have a complete verdict or a split verdict? Do we want a jury to work for a split verdict, to communicate with us on a split verdict? Or is it all or none? And what does each jurisdiction's judicial council and committee that goes over their jury instructions, their model jury instructions, what do they want? And what is their goal? And so it is different in every jurisdiction. But from everything I've seen, these instructions are some of them more confusing, but those are the instructions and they were followed by the court. Those instructions are confusing, but those are the instructions. So at the end of the day, the instructions might need to change, but that is up to the Commonwealth. They get to choose what is right for their jurisdiction, just like different jurisdictions have chosen to allow more open communication or encourage more open communication. But we're going to get deeply into conversations, and I'm going to get to questions instead. We're going to get deeply into conversations about judicial economy. Is it better for the court system to have cases either resolved entirely or not, or to do a trial, resolve a few issues, then do another trial, resolve a few issues, and piecemeal it? There are lots of conversations and weighing what is the most efficient and what each jurisdiction thinks is the most efficient. But those conversations do get to be had. And those instructions, again, all come from the model federal jury instructions. So the little things become important. So Friendly Farm Girl asks a question that I see a lot of you asking in the chat throughout. Why can't they just ask the jury? So asking the jury is generally a no, except in a very few narrow circumstances after the case is done. Polling the jury is allowed, but it is discretionary and neither side asked for it in this case. Generally, in the cases I have watched and in the jurisdictions where I practiced, jury polling was almost de facto. It was incredibly common, and the judges would generally say to the defense and the prosecution, do you want the jury polled? I never saw a defense team say, no. Do you want the jury polled? Everybody was like, yes. We always want the jury polled. Judge Kay in Florida didn't even ask. It's like, we will now poll the jury. We saw it in South Carolina. We will now poll the jury. It is, in some jurisdictions, just the common practice. We poll the jury in every case. We want to know, is this your true and correct verdict? Is this your verdict? Does this represent your verdict? Something like that. Because this jury wasn't polled, we now get into a different area of law where asking the jury questions has very, very, very narrow carve-outs for what's allowed. Murdaugh was one of those carve-outs. Even in Maxwell, we saw some of those carve-outs with, did a juror give information that was inaccurate on their jury intake form, and could that have changed the result? And could that have changed what the defense would have done? And that goes not to the deliberative process, but did the juror misrepresent something before they became a juror? So those are two circumstances we've seen in coverage. In Murdaugh, it was there outside influence? You're allowed to ask jurors, did somebody talk to you? What did they say? What happened? And you are allowed to talk about narrow and specific biases within the deliberation. And those are fairly narrow and rare circumstances, but the judges were pointing it out. In one of those appellate cases, it came up more than a decade later. And they went back and asked the jurors about what they remember over a decade later. The circumstance of the jury reached a verdict but didn't write it on the jury form is not within those exceptions. And that is why the defense has such an uphill fight on this, because it doesn't fit within the exceptions. If we're in a Murdaugh situation, it's much easier to poll the jury. If there is a concern that the jury has acted improperly, that there has been some type of juror impropriety, easier to ask. Asking jurors about their result is a very gray zone to asking jurors about their deliberative process. I agree with the defense arguments on this point that you can ask about the result without asking about the deliberative process, which you are not. The law is very clear on that. You no go. Do not pass go, do not collect $100, $200. You can't do that. But there is consideration from the Court of Appeals, and there will be, about is it skating too close to that line of getting into the deliberative process. And we saw, as my brain's buffering, and we saw them asking about that quite a bit in their process. We saw them really pushing back on, but isn't this asking about the deliberative process? Isn't the next question, was this a final verdict? So it is a very complex question. It feels like it should be an easy question. Like, just ask. What? Just ask. It is actually a deeply complex legal question, which is what makes all of this so interesting. Thank you, Miguelina. Yes. So let's get to a few more questions. You guys, I know today is a difficult day for let's explore all of the what ifs, flexible thinking that appellate law requires. But this is the appellate process in action. And this is how things move forward, though slowly. So it is how it moves forward. Samantha said, is it typical for appellate courts to handle both civil and criminal cases? Yes, they do. Which also, yes, they do. They do. So that is what they do. Wolfstud asked, love the stormtrooper mask. Since I said any further deliberation would cause them to compromise, doesn't that mean that anything they decided was final? I agree with you. And I think there's room for that argument. They said they don't need any further deliberation. They are hung, which leads me to believe they reached their verdicts and were hung. And I think you can ask those questions, but we'll see. Jesse said, did you and the other jurors reach a final verdict? They can't ask about the other jurors. That's deliberation. They can only ask about themselves. But yes, did you reach a verdict on count 1? Did you reach a verdict on count 3? Did you consider that verdict final? I agree with you. I think they can. But we will see what the court thinks. Again, I still think it's ill-advised for the Commonwealth to proceed on all 3 of those charges. They might, but especially after seeing what some of the jurors have said, or one of the jurors at least has said to Vanity Fair, the jurors weren't incredibly impressed with all of this. You know, the jurors didn't seem overwhelmed with excitement about the Commonwealth's case based on that juror's POV. All right, let's see. We're going to get into some questions, and then we are going to scoot because I have a team meeting. And then we're going to premiere the podcast at 11. I think it is a very, Miguelina, will you let me know how long the podcast is? The podcast is very long. I will be in and out of the chat today on the podcast. We have pretty stringent rules today in the chat, just because we are going to stick to the things that we are talking about. And I appreciate that. That is how we always are in the chat. So I appreciate it. The podcast is an hour and 40 minutes. So there is a lot of podcasts coming. This afternoon, I will be in and out of the chat. We have team meetings. We are talking about new Law Nerd Shop. I might actually go find myself some pumpkin spice something. But we also, as we are closing down Law Nerd Shop 1.0 to bring you Law Nerd Shop 2.0, the tumblers go away on Friday. So If you are interested in BOGO on the Tumblr's lawnerdshop.com, that is still available. I apologize, Canadian Law Nerds. Kristen, is there a closed captioning option? If so, please. There was not today. There was actually a note on the court's website that their closed captioning was broken, unfortunately, but on the replay, the closed captioning is available. Rachie said the podcast BTS was wild. Yes, it was. If you are not members, members in the Law Nerd Lounge at lawnerdlounge.com or here on the YouTube channel, record with me in the live chat, the podcast BTS, and see me sometimes struggle bus, sometimes podcrastinate, sometimes Emily liar, all the times podcrastinate, talking about other things. Today, last pod, it was pop sockets. So we do all of the things. So that is a lot of fun. KLV said, will this change the law to poll the jury eventually? Not a law, a practice. So will it change the practice? Maybe. What I think we will see first is in every case, I think we will see defense attorneys pushing back and asking in every case to poll the jury. So it's more of a question of practice, and they are allowed to poll the jury. I think it will change the practice, and what you will see is defense attorneys saying, I would like to poll the jury in every case. And that's often when defense attorneys see something happening in the line courts, it often changes very quickly. I'm sure Natalie Lawyer Chick has talked about this, but it often changes very quickly where the defense attorneys are like, so we're doing this now. We're going to just ask because they have more room. The prosecution can too, but it generally starts with the defense attorney saying, we're just going to ask to poll every single jury. And we're going to wait for the judges to push back. And then we can appeal that. And then the courts might give some more guidance. But what you will generally see is in practice, you will see the pushback in court, in trial, in every single line trial that happens. And so the practice will change first. And if a judge puts their foot down, then it will go up to appeal. So that's generally how you see things like that shift, where it's like, oh, there's something here. We're all just going to start asking for it and change the practice. Miguelina said the podcast is basically a movie. Yes, titled the shocking end of the YSL trial. Danielle said, so excited I never get to catch a live. I mean, it's an early one. It's an early one. Medicated moment. Thank you. I know. Kevin Stevenson, almost 2 years. Congratulations. Let's see. Judge Bev told the jury not to tell her or anyone where they were with verdicts until they completed all the verdicts. The foreman followed that, and that was the jury instructions. Music to my soul. That was the jury. That is the jury instructions. Those aren't made up. Those are the model jury instructions. Mike in the chat, thank you so much for the feedback. Mike, thank you. You are welcome. Thank you for mentioning it. I'm glad I saw it. Team Baker's here for the Law Nerds. We absolutely love this community. The decisions we make are community focused. The things we say yes to and no to are community focused. And the first question we ask is, does this make sense for the Law Nerds? The only time that is not true is when I am planning my concert schedule. There are times where I'm looking at my concert schedule going, wow, we're going to have a mobile stream and it might be terrible. That might not be the best for the Law Nerds, but sometimes we can find a compromise between Emily's concert schedule and mobile streaming. Sometimes we reach a compromise, and I know that you all don't mind. So it's like, is this what's best? Happy Emily is maybe what's better. When I am exhausted, everyone can tell. My face tells you when I am tired. Sometimes my vibe tells you when I am tired. So you can tell when we are just tired. Look, the Sarah Boone case was heavier than I anticipated. Truly. I knew there was a suitcase video. I knew that it was heavy. Everything else that came out that I was not expecting, it was a heavy case, and you can feel it. So you can feel it. Thank you, Nancy, for the gifted memberships. It's much appreciated. Words have stopped. I streamed for 5 hours yesterday. The brain needs to recharge. The brain is buffering, but we can normalize brain buffering after long streams. Lyrebird said, my brother is a contracts lawyer, specializes in the nitty gritty wordy stuff. Yes, the lawyers that fight over Oxford commas, other commas, what is the difference between a comma and a semicolon? Oh, yes, but it matters. And you can see why. When you talk about lawyers arguing over the placement of a comma and you watch the appellate court work, you can see why that happens. So for all of you asking about a ruling, that is not going to happen quickly. So if they come back before the new year, I will be surprised. Truly, I will be surprised. If they come back after the new year, that will be more in line with the time that appellate courts take. If they come back before the new year, I'll be like, oh, that was quick. Magistra, I hope I said that right. Emily, did you do research before this? I feel like I'm missing something. I did not do research before this. However, I have been a lawyer for almost 20 years and we covered these motions multiple times. So for my brain, that information is more normal for me to absorb because it is what I do regularly. It is just like people will remember baseball statistics and I am watching the World Series going, I grew up in LA, yay Dodgers, and I'm sure that others are like, never, I still don't know what a walk-off grand slam home run is, by the way. But others are like, they will know every statistic of everything and be like, never in a World Series has this or that ever happened. There are Dave Matthews fans. God bless. I love standing next to these people at a concert so much. Emily, are you going to diverge greatly? Yes, I've got a few minutes. There are Dave fans at a concert that I have sat next to. I love all of the Dave fans. There are some that know every single guitar switch, and they will look at what instrument Jeff and Rashawn are holding, what guitar Stefan has, the bass player, and what guitar Dave has, and be able to be like, oh, it's going to be this song. Because they know that combination of instruments means it's going to be this. When Dave switches guitars, they're like, oh, it's going to be this or this because that's what he plays with this guitar. My brain could literally never. And I am so fucking jealous. I wish I knew. I have been to 60 plus Dave shows. I still don't know. There are times I can tell based on, there are very few things I can tell. Occasionally, Stefan's guitar, occasionally which saxophone Jeff breaks out, because the massive one is only a few songs. And I'm like, haha, I've narrowed it down to the one massive saxophone. That's about all I've got. But I love the DMB music nerds that know exactly what's coming. My brain doesn't do that, but my brain can do that with law. And it's because it's the way my brain has been trained for the last 20 plus years. And so going over the arguments at the trial court level multiple times and then going through the briefing here, it's just what I remember. So no, I didn't do research before. Everything I've done, I've covered here, but it is what stays in my brain. I mean, that and lyrics from songs and movies. I saw Tamil asked in the chat, how did Travis do yesterday? Well, he got to teach choreography to his colleagues and he did it well. So yeah, he was happy. And look, I just go by vibes with him. He was happy. So I don't know. I didn't get to see it, but he was happy. And teaching others to do the thing that you do is a incredibly different skill than just doing the thing you do. So I'm happy that he took it on. So Sarah said, thank you. You are welcome. I am here for the law nerds. Habda's like, you're here for emotional purposes. Look, I am happy to be a comfort stream. Don't worry about it. Bex, which is why we're in our comfort clothes today. I am starting to get hot though. It is I got a warm, cozy robe for this winter because I needed one. I was just, Against the Tide asked, how did the band do during BOA? They did their best of the year. They are not the largest band in our region, and that can make it difficult. But they did the best they've done all year, and that is really all you can ask for, is to leave it all out on the field. Truly. Which is sometimes hard when you leave it all out on the field and you're like, well, that still didn't go how we wanted it to, but you know. So there are larger bands, and they knew that going in. Sometimes it is hard to compete with the Southeast. Some of the high school bands are fucking college bands. They are just, they are so they are massive college-sized programs, like multi-hundred thousands dollars programs. Just, it's insane. It's delightful, but it's wild. So I am always impressed looking at a couple hundred kids on the field. It's absolutely impressive. So our program is definitely growing, and our band director is incredible. Just absolutely incredible. So I have nothing but good things to say. And you can't be mad when kids really do give it their all for a season. Abigail said my high school band has 250 to 300. Damn. It's a massive band. That is a massive band. Massive. That is a massive band. That's impressive. And it's fun. Like, it's just fun. And the judges can be swayed by fun. It's so hard in the any of the creative arts because it's also subjective. I played water polo. Who had more goals at the end? That's who wins. And you know where you stand. You know if you're winning or you're losing. When you're running, you're like, hey, it's just me, boo. But in the creative arts, it is so subjective. It is hard to know. But there are some things you know, and sometimes that big sound is just overwhelming. Rachel said, my sister marched with the Pasadena City College Band for the Rose Parade. The Rose Parade is so cool. I still get up to watch the Rose Parade. I still have lots of emotion for the Rose Parade. And I love getting up to watch the Rose Parade. I love seeing all the bands. I love seeing all the floats. It is something I'm very nostalgic about. I generally eat pumpkin pie for breakfast while watching the Rose Parade and playing mobile games on my phone. Emily, really? Yep. It's exactly what I do. Love it. Sometimes my kids join me. Sometimes they don't. Sometimes my husband joins me. Sometimes he doesn't. But I'm like, I love the Rose Parade. Danny said, listening from work today. Good morning. Good morning. Jay McCarthy said, why are they so against polling the jury? I don't think they're against, the appellate court, because it's not the usual thing and it treads the line close to jury deliberation. The trial court, I think they're going with nobody asked. And I don't think that's going to happen again. I imagine in every case going forward in Massachusetts, the defense attorneys are going to be like, we're fucking asking. We're asking. I imagine every defense attorney is going to say, yep, we're going to ask. Nashay said, I have a bit of good news, y'all. I got word that I received the Creative Philadelphia's Illuminate the Arts grant. I am so excited for you, Nashay. Hold on. We're going to get some applause here. You guys, we're going to celebrate our honored Nashay real quick. I'm very excited for you. Woo! Give it up for Nashay. Congratulations on the grant. That is a huge, huge win. And it is fun to be able to celebrate with you. So thank you for sharing with us. You've kept us in the loop on all of the creative journeys, Nashay, and I am so excited for you. So congratulations. And I love seeing the Lawnards in the chat congratulating as well. Let's see. Katrina asked, but why didn't they ask Bev to poll them? Is that the issue? Katrina, it's part of the issue. Why didn't they ask? I don't know. I don't know. It was fast. Why decisions are made, it's like watching Survivor. It's like, why'd they do that? That seems weird. Why things happen in the split second you have to make those decisions, I don't know. The problem in law is if you make the wrong split second decision, you might lose the argument forevermore. And that is a difficult thing. So I wish the jury had been polled too. We probably wouldn't be here. AJ looks like he wants to jump out of the chair. Probably. It's real hard to sit on your hands and not argue. But he grew out the beard. He's going to have to just rub his face. I don't know. There's not much that can be done. Jilly Bear said, thank you for creating this awesome community. Jilly Bear, I will offer that all of us have created this amazing community because it is not just me asking like, hey guys, can we talk about like what we're on topic for today? It also takes the 10,000, sometimes 50,000, sometimes hundreds of thousands of people in the chat to also say, yeah, I'm on board with that. Like it is, we all agree together, and the incredible mods that are like, we've got you. We will also help protect this community because that comes first. So all of you participate in this wonderful community, and I appreciate you so much because the Lawnards are all over the world and all different backgrounds and life experiences, and we can still come together and have conversations about the law, even when it's like, I understand the way the law is going. I don't necessarily like the result. Or I understand why the law did this. I don't necessarily like this defendant. There are very unsympathetic defendants who we have still sat there and been like, yeah, but I don't love this person, but that's fucked though. And so being able to separate the person from the thing is important. Being able to look at what's going on in the law and starting to watch those trends and see what's happening in our courts and look at how juries are making decisions, look at how cases are being presented, and look at what's happening day in and day out is, I think, a tremendously important thing and a really helpful thing to understand how all of this works and to be able to have nuanced conversations on the internet without name calling. And there are days it's hard for everyone to not name call. There are days it's hard for me. There are days it's hard for you. And we've all learned to be like, you know what? I can be more constructive in my feedback. I can say, I don't like this argument, or that is not well taken, or that this is a bit ick. But we can still separate that we don't like the thing that's happening from the person, and not name call. You know, there were days that it was hard not to name call Lally. Days, because dude. However, we were still able to look at that case and be like, I am not persuaded by this argument in the least. I find this line of questioning grating. And to be able to go through critique and evaluation without defaulting to ad hominem attacks. And that is, I also think, an important skill, because there was room with a lot of these cases to critique the attorneys. I also think the attorneys are the most fair game for the most criticism because they chose to be there and this is their sports. If we can criticize baseball players and football players, we can also criticize lawyers. It is basically the same. Tangling with Gina said, I got to watch the U.S. Supreme Court once. It was amazing. It's fascinating to watch appellate courts in action. I really appreciate that the Supreme Judicial Court broadcasts this through their website and broadcasts it and says, you know what, you can broadcast it. Just here's a link, go ahead and broadcast it. They also allowed cameras in the courtroom. They were like, this should be open. I very much appreciate this appellate court being like, this should be open. I hate that federal courts are so closed. But maybe that will change, law nerds. Maybe we can focus on why federal courts want to be so closed, perhaps. Daniela Kay said, don't they question the jury before they read the verdict? No. If they can ask, have you reached a verdict before publishing it? If they should be able to ask the jury the same thing, they should be able to poll them and say, is this your verdict, like we saw most recently in Sarah Boone, where jury number, was it 3 or 4, was just like, yes, it is. They let you know. Ford Doherty said, do time limits mean nothing? The judges were still asking questions, so they were allowed to continue on. Let's see. I guarantee you, if we see a retrial in the Karen Reed case, which we'll see at least a retrial on the second count, they're going to ask to poll the jury immediately. Lawnard Junkie, it is not double insulated. It is a metal cup, but it is not double insulated, double walled. Lonnie said, do you think it was a good point that the judge deviated on the third note as opposed to how she handled the first and second? I think it was a good question because the judges are thinking about, right, but would the defense expect that the judge would show them this? AK said, I think I love appellate court. It tickles my brain. It's definitely more like a tennis match. Redondo Beach said, you are inspiring me to go to law school. Well, if you enjoyed that back and forth process of appellate court, law school will be a lot of fun for you. Absolutely. All right, y'all, I've got to bounce to our team meeting and let Miguelina get to our team meeting, and I will see you soon. I will be in the chat when we premiere the podcast this afternoon. We're going through the YSL verdict. At the end, there is a quick update on Diddy's lawyers are so fucking pissed. But after a 5-hour stream yesterday, it was quite a lot of work for the team. I am going to look at what time there are hearings tomorrow, and we might shift our schedule for tomorrow, depending on my schedule and depending on hearings in Idaho tomorrow. So stay tuned to the Law Nerd app. Don't forget that the Law Nerd Store version 1.0 is closing. 2.0 is launching later this month in time for the holidays. Your tumblers are waiting for you. There are some left if you want to go grab a tumbler bundle, because these are also going away. So if there are things you love in the Law Nerd shop, now is the time to get them. Thank you for being here. Thank you for being a Law Nerd. I will see you in the chat. I will see you tomorrow. I will keep you updated in the app and here in the comment section, in the community section when we are streaming tomorrow. I have to take a look at all of the things to see what time stuff is, but don't worry. If we don't cover it tomorrow, we will cover. But I'm going to see everybody being like, not music court getting bumped. I know. We'll see what the hearing's about tomorrow, and we'll go from there. Law Nerds, we don't want to miss live court. I know that takes priority. So with all of that, let's roll the outro. I will see you soon. Always happy to be here with you. Happy for a Wednesday stream. Let me know if we love a Tuesday, Wednesday, Thursday stream situation, because it feels like we're just running a 3-day-a-week morning show up in here, and I am here for it. So thank you for joining me today. Thank you for joining the Supreme Judicial Court of Massachusetts, and we will see when they rule. Let's have a good one. It's time for coffee, more coffee, and I will see you guys in the chat on the podcast. Bye. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.